I'll let them talk about these with you. Thank you. Ms. Regan, please.
Dr. Dudley, could you inform the jury of your name, please?
Richard, middle initial G, Dudley, D-U-D-L-E-Y, Jr.
Could you spell your first and last name?
Richard, R-I-C-H-A-R-D, Dudley, D-U-D-L-E-Y.
And what's your profession?
I'm a physician with a specialty in psychiatry.
And are you licensed to practice medicine?
Yes, I am.
And where are you licensed?
New York.
Now, where did you go to undergraduate school?
I graduated from Wheaton College in Wheaton, Illinois.
And where did you go to medical school?
Temple University School of Medicine in Philadelphia.
And what year did you graduate from medical school?
1972.
And did you do a residency?
Yes, I did.
And where did you do your residency?
Northwestern University Medical Center in Chicago.
And what was your residency in this particular area of medicine?
In psychiatry.
And what kind of work did you do during your residency?
In addition to being a resident, I worked at a community mental health center in Chicago.
And what was the name of that center?
Lower North Mental Health Center.
And what were your responsibilities at that mental health center?
At that mental health center, I did medication evaluations, supervised some of the other staff, and then worked in the juvenile program there.
Now, what were your...
We also did... The mental health center there was a high school within its area, and so that many of the juveniles who needed mental health services received group therapy at the right at the school itself. So we ran those groups as well as at the center.
And what age range of children and teens did you treat?
They were from about 13, 14.
Now, are you a member of any organizations?
Yes, I am.
And what organizations are you a member of?
I'm a Distinguished Fellow of the American Psychiatric Association and a Fellow of the American College of Psychiatrists.
Now, what is the American Psychiatric Association?
Psychiatric Association is the membership association for all psychiatrists, and any psychiatrist is able to join the APA.
And what does it mean to be a distinguished fellow? A distinguished fellow.
Living.
Yeah.
The work has been what your accomplishments have been.
If you remember.
I don't really remember, but it's been some years.
You also mentioned you were a fellow of the American College of Psychiatrists.
That's correct.
Now, what is the American College of Psychiatrists?
The American College of Psychiatrists is a much smaller body. You have to be nominated and elected to become a member of the American College of Psychiatrists, and there's a fixed number of members, and so someone has to become emeritus or age out before voted in.
And what does it mean to be a fellow?
The process that there's a committee and they look at what you've done over the years and then propose to fellow.
Now, what is
diagnostic disorders, and so it's a handbook that's put out that describes disorders. They're divided into broader categories and then with specific psychiatric disorders, and it would list the diagnostic criteria for each of those disorders. So it would talk about what symptoms you have to have. If there's some requirement that you have those symptoms for a certain period of time or something like that, it would discuss that as well. If there are things that you have to consider in distinguishing one from another, like, were there drugs involved, or is there some sort of medical problem that may have caused the same symptoms, that sort of thing would be listed as a diagnostic criteria as well. And then in addition, some additional information about each of the different disorders, so there may be information about whether it can occur in children, to occur in men versus women, or what the course may be over time, or provides other kind of information about each of the disorders.
The DSM.
The American Psychiatric Association.
And what?
It plays an important role in the field of psychiatry in that it's, to
the diagnosis. Now,
5 means that it's the 5th version of this manual.
Prior.
When they do this, and then I became deputy commissioner. Well, as a special assistant to the commissioner, my responsibility was essentially helping the commissioner, doing whatever assignments she gave me, working with her and helping her to complete her tasks. As deputy commissioner, I was responsible for the programs within the department. In New York, this department was essentially in contract with all providers of mental health services, and the city generated income from the provision of services that they provided. But in communities where there were what we used to call then working poor people, they therefore couldn't qualify for like public assistance or welfare or things like that, but they didn't have jobs that provided other sorts of monies that would allow them to get mental health services. And so funding came from the department to help those agencies serve that population. And so as a result of that, the city was responsible for monitoring those programs for quality of services, making sure that they were adequately staffed, making sure that they were serving the populations that they were supposed to serve, helping to develop programs if there were gaps in services. And we had groups that looked at these issues and made sure that that everybody who lived in New York City had access to the range of mental health services that seemed to be required.
Now, how long did you work for the Department of Mental Health in New York City?
I think a little over 2 years.
And backing up, how long did you work at the Mental Health Center in Chicago?
About the same.
Now, and approximately what year did you leave the Department of Mental Health in New York City?
After.
May the witness refresh his memory.
Okay. I left the city department in December of 1977.
And did you assume another position at that time?
Yes.
And what was that position?
I became medical director of the Washington Heights, West Harlem Community Mental Health Center.
And what were your responsibilities there?
Well, it was a totally new newly funded program. This was back in the day when they were funding full-service community mental health centers that would be responsible for delivering mental health services to a particular community. And so that each of these centers had a whole range of services that they were to provide, ranging from everything from therapeutic nurseries for children who were born with various sorts of mental disabilities, through children's programs, through adolescent programs, through adult programs, substance abuse programs for the elderly, just a whole range of inpatient services, emergency services. And so this was a newly funded community mental health center. And so as the medical director, my responsibility was essentially to open this center, to hire the chiefs for each of these services that work with them to then begin to staff up and design and implement each of these programs. And then once the programs were open and set up, to then supervise the program directors.
Now, did you have direct contact with clients in that position?
Yes, I did. Obviously, when you're trying to start a new program, you're going to have gaps. You're going to have staff that you can't find yet, or positions that are not filled yet. And so during that time, in addition to running the program, I functioned as the psychiatrist in the adolescent program.
And so you did see teenagers.
Yeah, I did evaluations, I helped supervise the staff in that program, did medication management for kids in that program, etc.
Now, did you also work as a consultant for the Children's Aid Society?
Yes, I did.
And what is that organization?
The Children's Aid Society is a fairly large program in New York. They provide a variety of services. They do some foster care. They have centers, different sorts of community centers that they run for kids. But they also run a series of mental health clinics for children and adolescents. And I worked in one of those centers. When I was working for the city in the Department of Mental Health, Mental Retardation and Alcoholism Services, it was an opportunity for me to maintain clinical work by working with the Children's Aid Society. And I was able to do that because it was one of the few programs in the city that wasn't in contract with us. So it wasn't a conflict to work with them.
And approximately what years were you a psychiatric consultant to that organization?
76 up through 82.
Now, I'd like to ask you about teaching that you've done. Now, have you taught at New York City Medical School?
The longest stint was at the City University of New York Medical School at City College. That's an interesting program. It was a program that was designed some years ago to increase the population of physicians in the various different neighborhoods throughout New York City. And so it was a program that attempted to recruit kids right out of high school, and they came into a 5-year program. And during that 5 years, they would get their undergraduate degree and also complete the requirements for the first 2 years of medical school. And then if they successfully completed the 5-year program and passed the first part of the medical boards, which they would then be guaranteed a position in one of the 5 medical schools in the state of New York. And then they would compete amongst each other for the slots in the different medical schools in New York. And so it was a way of recruiting and increasing the population of kids from the various different communities, from Chinatown, from Harlem, from the different communities within New York. And that the students who went through would commit to returning to their communities and practicing medicine there. And so I taught there for some years, and for some years I was the director of the behavioral sciences part of that program, which was the program where the students would issues, but also that was learn to do things like how to interview, like their bedside manner, understand, but because the focus of the school being on the city and populations in the city, there were enlarged segments of that training program dealing with the kinds of problems that you would find in the city. So all medical schools have a behavioral sciences program, but ours was maybe twice the size of and trauma and violence and things that they were going to come work as physicians in the city.
And what were the years that you were an associate professor of medicine at that medical school, approximately 1985 to 2005? Now, have you also taught at Lincoln Hospital?
Yes.
Can you explain your position there?
I taught at Lincoln Hospital before that. That was part of New York Medical College, and that teaching responsibility was primarily with residents who were training to be New York Medical College through the psychiatry department at Lincoln Hospital, and so that job was essentially supervising and teaching the residents who were rotating through.
And at both these teaching positions at New York Medical School, were you involved with children and teenagers?
At New York Medical College, I basically focused on my teaching responsibilities of the residents were twofold. One was supervising them with regard to, as they were learning how to do actual individual therapy with different patients in the psychiatry clinic, and the other part of my job, residents who were on the consultation liaison service. The consultation liaison service is a service that the psychiatry department provides when other departments need a psychiatric evaluation, medicine or whatever. And so in that regard, and my part of that was working with the residents when they would go out to do evaluations, either in peds or working with other adolescents.
Now, have you also taught at a law school?
Yes, I have.
And what law school is that?
New York University Law School.
And how long did you teach at NYU Law School?
1984 to 2005.
About 21 years.
That's right.
And what were your teaching responsibilities?
I think the easiest way to explain it is that I generally team taught with an attorney, and it was in various different settings, but it was generally focused on the use of experts in different sorts of legal proceedings. So what I mean by that is that over the course of the years, it was always a team teaching, it was always about expert evidence, but it was in different sorts of courts. So we started out, when I first started there, we were talking about the use of experts in family courts and in juvenile proceedings. Different points over the course of the years, it was criminal courts, different sorts of.
You stopped teaching in 2005?
That's correct.
And why was that?
Um, I was feeling that it was time for me to begin to slow down, just given the number of things that I had been involved with for all of those years. And so that's 2005 was when I kind of started this process of dropping certain sorts of categories of things that I was doing. Back a little.
Now, are you board certified in psychiatry?
Yes, I am.
And where is that certification from?
For all physicians, and it's the same for all specialties, is a national process. And so just like in all the other medical specialties, there's a board of the American Board of Psychiatry and Neurology certifies psychiatrists and neurologists. And so it's a national exam that's given by that board.
And approximately what year did you take that exam?
1978.
And would you like to check?
I'd like to check. I think that's right. You had to be out of your residency for 2 years back then. That was, and so that's why I did it.
And you've been board certified since then?
That's correct.
Now, is there a subspecialty in forensic psychiatry?
Is there a subspecialty?
Subspecialty certification in forensic psychiatry?
Yes, there is.
And do you have that?
Subspecialty certification started in a decade, and I just never went back and took that exam.
Now, examiners, psychiatry and neurology.
The board exam in psychiatry is a two-part exam. There's a written exam first, and then if you pass the written exam, there's an oral exam in which it's changed a little bit over the years, but in which there's two examiners, I'm sorry, who watch you actually do evaluations and then question you on those evaluations. So the oral exams back in the old days used to be a combination of actual patients. It's essentially an oral exam to assess skills but you can only written exam.
And have you served as an examiner for the Board of Psychiatry? Now, did you have a clinical practice for many years?
Yes, I did.
And what is a clinical practice?
Well, that was the part of my practice that was focused on the evaluation and treatment of patients who presented to me for psychiatric evaluation and treatment.
And in your clinical practice, did you see a patient once, or did you see a patient over time?
Most of the patients I saw over time.
And
I began a clinical practice as soon as I finished my residency, which was I started that in the beginning of 1976 when I came to New York, and always had a small part-time clinical practice, and then in the early 80s I went into full-time private practice, and seeing patients was about 50% of my time.
And what year was that?
That was about 5 years ago.
And did you end that because you
That
were...
was the next step.
All right. Now, what type of patients did you treat in your clinical practice?
I practiced on the treatment of men of color, mostly African American and Latino men and adolescents.
And did some of those patients And did you follow them? Did you treat them for lengths of time?
Well, some of the ones with more severe mental illnesses who were on medication, I mean, I saw them for many.
Pardon me?
I said for some of them who were more severely ill and were on medication, I saw for many years. I mean, 20 years or so.
And what were those patients diagnosed?
We're all over the place. I mean, some had bipolar disorder, some had schizophrenia, so different diagnoses. And many of the patients were, I would say my patient population was a whole range. I mean, some were reasonably healthy people who were going through some sort of life crisis and were in treatment time. Others were people who had major kind of underlying characterological that bipolar disorder or whatever, and who were on some sort of combination medication.
Now, what are forensic evaluations?
Forensic evaluations are evaluations done in the context of some sort of legal proceeding.
And when did you begin doing forensic evaluations?
In the early 1980s.
And in what courts did you start doing forensic evaluations in?
I started in the family court. The family court in New York, I believe, is a little different than here, in that they do they do several different sorts of things. One is that the family court is where a lot of family problems are, and so that I would be doing evaluations in situations where there had been a finding that a parent had abused or neglected their child in some sort of way, and so the evaluation was to help the court decide, once they had concluded that that had occurred, what should be done. Could there be a plan to eventually kind of help that family and reunite them, or was there such a large problem that was unlikely to occur? That the parents suffer from some sort of mental illness that was interfering with their ability to care for their children, or was there some sort of intellectual disability that made it impossible for the parents to care for their children, whatever the issue was. So the evaluations were focused on that. They also dealt with custody disputes when there was some sort of a divorce and there was a fight over who should have what responsibilities for the children. But our family court also is the juvenile court. We don't have a separate juvenile court, and so the juvenile proceedings are held in the family court as well.
And that would be juveniles that were charged with a crime?
With a crime.
The age range of the individuals that you did forensic examinations of in family court in New York?
So the cases you were involved in the juvenile court, that you would see fairly young children. I mean, sometimes always that were not moved to adult court, but who were continued to be seen in juvenile court. In the child abuse and neglect proceedings, you might see young children who had been exposed to some sort of abuse and neglect.
And so about what year did you start doing forensic evaluations in the family court in New York? And did you expand the courts that you did forensic evaluations in?
Well, when I went into full-time private practice in '84, then forensic, and about half of it was the clinical practice of seeing patients. So Well, I mean, what happened initially is that I went from working to also doing juvenile cases that had been pushed into adult court. And then once I started teaching at the law school, different other law professors were recommending me to other people, you know, when people would call the law school. And I started criminal doing habeas post-conviction cases and capital sorts of adult cases, and then eventually
So you started doing forensic evaluations in 82 to 83, correct?
that's correct.
And have you done them continually? Still doing them now?
Yeah, I'm still doing that.
So you've done a lot of forensic evaluations.
Over these years, yes.
Testified as an expert witness before.
Yes, I have.
And do you know how many times?
I don't know how many times, but certainly for many, many years, a year or so. It's slowing down a little bit now, but in the last couple years, but average for most of those years.
In what types of cases have you testified as an expert witness?
Let me just go. What kinds of cases has evolved as I just described? Say for most of those years, I testified in cases, some of them capital cases, and then I've also in cases in appeals of capital cases and in civil different sorts, and of family court cases.
Now, when you're called, have been called as an expert or delinquency matters, have you been called by the defense or the prosecution?
It depends. In the death penalty cases, I've always been a defense expert in death penalty cases. In other, a little bit of in a variety of things, but I would still say mostly a defense expert.
And why is that?
Kind of the 50-50.
And is there a reason why you've mostly testified for the defense?
That's who calls me.
Okay. Now, are you on any boards of directors? Are you on any board of directors of any organizations?
Yes.
Or were you?
Yes, I have been over the years.
And what organizations?
Well, I'm currently on the board of Housing Works, which is a in New York that provides housing and a range of health and other services to people who are HIV positive. I was on the board, just recently left the board of the Vera Institute. The Vera Institute of Justice is a organization that's been around for some decades that does a lot of research, and out of that research identifies may increase justice in the broadest sense of the word, so not just criminal justice, but related issues. And then they will come up with a demonstration project in cooperation with some government. Try it out, see if it makes a difference, see if it makes over, and then develop and expand. Things like community policing was started out as like a Vera project. They tested it in certain areas, and then when it seemed to be helpful, began to then expand.
Now, Have you published articles?
Yes, I have.
Have you published articles in peer? And what does it mean for, what is a peer-reviewed journal?
A peer-reviewed journal is a journal, it's exactly what it sounds like, in which other people in the field review and comment on the paper before it could be.
And have you recently worked with the Kennedy School of Government?
Yes, I have.
Can you explain?
The Kennedy School, Harvard series of what they call executive sessions, where they bring together experts in some particular area who will meet over a period of time to kind of struggle with issues related to a particular area. This most recent executive session was on, again, on policing, and so it was chiefs and social scientists and different sorts of other people who were expert in this area who came together to struggle with, and so that's what they, and then they publish reports and papers.
And on what subject was that report?
It was on children who had been traumatized when they were children, and what the psychological consequences of that, and how does that affect their behavior, particularly given that it's clear that many of these children have been. And so it looked at, well, you know, what would education of police on this helpful in
about from and what were your responsibilities there?
There that developed educational programs for physicians, and that's where I worked.
Your Honor, I've completed.
Ladies and gentlemen, we're going to recess. It's hard for me to get. Don't discuss the case among yourselves. I'll do when you come back. Jurors are excused. Court will remain. Once again, watch the step going out. Okay, yes, Ms. Regan, there's some, he knows he can continue to just catch up while we're on the break, right?
I'll make sure.
Okay, thank you.
Now, the defendant has filed a motion to admit on direct examination the defendant's recitations of his past experience to defense psychiatric expert Dr. Dudley for their truth, or as necessary to permit the expert to relate his assessment of the defendant. The Commonwealth has filed a counter to that and a motion in limine to preclude the introduction of self-serving hearing.
Okay, well, I guess my, this is, I wish we had the same rule that they have in under the Federal Rules of Evidence, where if the court found the opposite of Mass Evidence Guide 403, that the probative value substantially outweighed the danger of undue prejudice, the opposite of 403, that the basis could come out on direct. I think that would be helpful for jurors. I think that judges would be careful in crafting that, and what I think on this matter doesn't matter. We got in Chapel. How long ago was that case? A couple weeks ago. They to issues of criminal responsibility, but in all of the autopsy cases, the DNA cases, the common law confrontation cases, has that they seem not to have any intention of moving off of no. I certainly understand the reason for the request. Even if you don't think that you're going to win the request, you have to file it. But I have to follow the law as the SJC has it now. There's nothing I can do about it because I have a different view of it, which you'll excuse the redundancy, I do. It doesn't allow me to Chapel a couple weeks ago.
Well, Your Honor, it's the statements that a defendant makes with the 14b2 under the rationale of Blaisdell. And in fact, that the reason that the Commonwealth even gets a chance to evaluate the defendant, notwithstanding his right against self-incrimination, is because his expert is going to be testifying based on his statements. It puts the defense at a great disadvantage that our expert cannot discuss the most relevant information to his opinion, which is what the defendant told him about. So for the reasons set forth in our memorandum, I object to the court's ruling that the expert cannot testify concerning statements that the defendant made to him that are the basis for his opinion. I object to the court's failure to permit us to admit those statements. I believe the defendant has moved to admit the statements as necessary to permit Dr. Dudley to relate his impressions as to the defendant's interpretation of his own experience, the emotional balance of his memories, his thoughts, speech, mood, and effect, subject to a limiting instruction that they can't be taken for the truth of the matter asserted, but how they inform Dr. Dudley's a little more clearly in that was filed here.
All right, let me read it. While I'm reading it, my first comment is I think it's, when I say that I wish that the equivalent of Federal Rule of Evidence 703 was adopted, civil cases, criminal cases, for the Commonwealth, for the defendant, but again, it doesn't matter. It's just about 10 days ago now. When I say that I wish that the equivalent of Federal Rule of Evidence 703 was adopted, civil cases, criminal cases, for the Commonwealth, for the defendant, but again, it doesn't matter. It's just about 10 days ago now, this issue, after being briefed before the SJC, they said, but let me it's not the fact that it was medical records that was central. The defendant can get every one of these statements in evidence if the defendant wants to, just like they could get the medical records in evidence. It's the defendant's strategic choice not to do so. I don't mean that as a supportive statement of Mass Evidence Guide 703 and the case law behind it, because I've already told you my view on that.
Well, Your Honor, in this case, the defendant's statements to Dr. Dudley are particularly relevant.
A circumstance. And so I understand your argument. Do you want to add anything else to it?
No.
Okay, Ms. McDougal.
Perhaps not getting the full tenor of what Ms. Regan is proposing to do, which could be equally, the Commonwealth would suggest, a problem on redirect as direct. Obviously, Chappelle of opinion on direct and cannot elicit statements of the defendant. I'm concerned that the defense seems to believe that at some stage they can elicit the defendant's statement. They would ever come in for the truth through their expert, or that they can have the defendant was telling the truth, which again, he can certainly interview the defendant, but I don't think he can opine on the credibility.
Witnesses, absent use of which is vehicle very rarely, but facilitation is the only time one witness can say whether another witness reputation forms. Way to contemplate that could happen, and even on it's not in for its truth; it's in for the basis opinion. While this is a very complicated area of law, it's not an just in the substitute examiner and there's nothing that interferes. The Commonwealth can get in those opinions, or DNA case. As a matter of fact, it's more difficult for the Commonwealth to get in because of confrontation grounds. The defendant may proceed through opinion. The defendant can include, can't get into the base. Whatever, that report, I spoke to the defendant on X amount of occasions. That's to do, and you can do that. All right.
court to note a continuing objection on that matter, because it would be very awkward for me to ask the questions and sustain the objections during the direct of Dr. Dudley.
The short answer is yes. The longer answer is, I don't know how you could reserve this issue any better than you have as it relates to what you view are the impediments relative to and that this provides if there were a change in the law that it would come in for its truth. There's nothing that suggests in other jurisdictions under the federal that somehow that allows you to import hearsay in for its truth. That doesn't exist at all, and that would be a 180-degree pivot for that. So that's reserved too, but I don't see any possible arguments or basis for that, or doctrinal framework that exists anywhere for that. All right, yes, you have a continuing objection.
The next motion, statements that the defendant made to Dr. Dudley concerning his present state of mind. These would be statements about symptoms that he was experiencing during the interviews, and lack of memory and feelings that memories presently give him.
So is there any case, because it would, because if what you're referring to in 803.3 and 803.4 were to apply in these types of situations, then there'd be no reason for all this case law precluding it. I mean, this is not, it seems to me, within the contemplation of then existing mental or physical condition exception or statements for the purpose of medical diagnosis and treatment as the SJC has contemplated it in the past.
Commonwealth v. Whitman says that it is the statement of the fact I am presently hearing voices. The defendant has made that statement. It's admissible.
In an artificial environment, criminal responsibility or a competency evaluation, of course it is, but not in that context. If the defendant said, "Mother, I'm hearing voices," she can get on the witness stand and say, he said he's hearing voices. She can just walk right up here and say that. If he said it to somebody at Danvers High School, she can get right up there and say it. If he said it, "See, I am hearing voices," that person could get right up there and say it, and I won't go on and on and on. Of course you could. Of course it could.
But are you saying that Dr. Dudley can't say that the defendant said to him, I am presently hearing voices?
Saying that the basis for the expert's testimony on direct.
Unless there's an exception to the hearsay rule. This is the defendant's defense, that Dr. Dudley can testify to what he observed as the defendant's present state of mind, the symptoms that Dr. experiencing when he met with him,
Sure.
the feelings that he exhibited, and if he had a lack of memory. These
Yes.
are things that he can testify to.
That's true. All those things he can, absolutely. He can testify that. And he can also say that he's basing his opinion on, he can do that too. That you can do, maybe nothing, I'm not sure. But what you can't do is say, well, the defendant said X, Y, and Z. The reason he can't do that is that the SJC in this context hasn't applied those hearsay exceptions. But let me hear from Ms. McDougall, and if you want to add anything, you can.
Your Honor, I just feel the need for the sake of the record to clarify that's not what Whitman says. Whitman says, and in fact in Whitman, the statements were not allowed in because they were 2 weeks prior to the murder that the defendant had apparently told two friends he was hearing voices, and so they weren't allowed in as being too remote in time. But certainly if there were statements around the time of the murder that the defendant had said, I am hearing voices, the Commonwealth doesn't disagree that under Whitman they would come in. They clearly do not come in when made to Dr. Dudley, and Whitman does not stand for the proposition that they do.
No, court, it's first of all, it's not even an issue that's a close call. The relevance would be that just to talk about the relevance, forget about the hearsay. The relevance back about something 2 years later, and that's state of mind looking to the past. And we know that the state of mind exception does not allow state of mind as to the past. And so the statements, what the defendant said his state of mind was in the past, with one exception, and within the state of mind exception. Dozo said in Shepard versus the United against hearsay, if those type of statements fell within the state of mind. State of the law doesn't seem to me to be unclear as to these issues. I also, not that it needs to be reached, but there's also a relevancy issue. But certainly statements as it relates as to present, then existing state of mind in October of or within a reasonable time thereof, certainly does fall within 8033 and would not be in any way precluded. Nothing precluding the defendant from putting that type of evidence in if the defendant wants to. Nothing at all.
Your Honor, the fact that he was hearing voices when he was examined by Dr. Dudley is relevant, and it is not hearsay. It is part of the exception to the hearsay rule that's discussed in Whitman. It's critical to the defense, and all of this is retrospective because of the nature of a forensic evaluation. It's clearly relevant. The court has found that his state of mind that we have is relevant with the admission of Dr. Jackson's testimony and the release of the 15A and the 15B by Dr. Present state of mind, even that far in advance.
For a reason on defense, which is not a probative value back 2 years ago, but that that the nature of a psychiatric disorder 2 years later might have going back to the time based on so I don't know what to say. I understand your argument. You're saying that the room and says X, I feel such and such, do such and such within 033. My arm hurts, or to not talk tomorrow, or that I feel confused, or 8033, and of course by the strict definition, issues, but that would eviscerate the whole principle to the way expert testimony is addressed. It does not mean that isn't going to get it, that that he talked to him and there's a basis for the opinion, and he's saying that he was hearing voices. I mean, that's the artificial nature of Nardi. Established case law.
But established case law prevents Dudley from testifying about the defendant saying all the times in the past he heard voices, about all his prior, talking about information that is kept. Okay, that's about that. This is a different, turn the rule on its head. It's a narrow exception to the rule. The narrow exception is present statement of present state of mind, present medical condition, present memory, the present sense exception. That exception applies to Dr. Dudley, and it's relevant because it informs his opinion.
Well, then let me ask you this. Why wouldn't the, for the purpose of medical diagnosis and treatment, allow all the other statements in?
Because this was not, this is a forensic interview, it wasn't medical treatment.
It's diagnosis. Why isn't it that I mean, it's true, then it's just as true for 8034 as have probative value on 8034 and 8033. But nonetheless, I am not ruling at this moment on redirect. I'm not ruling on this moment on redirect. There are implications on redirect that that you'll need to think about before you ask the question, if you're allowed to. But I'm not saying that what you anticipate the cross is going to be isn't going to allow for this narrow area. I'm not saying it is, I'm not saying it isn't. I haven't heard the cross, I haven't even heard the direct. So let's see what happens. But keep in mind that if 8033 applied, first of all, the 8034 exception would have way more relevance. Statements that look to the past, and it is for treatment. So it'd have way more relevance than 8033. What is the then existing state of mind 2 years later? What's happening? There's a huge probative value. Just assume you get over that probative value. I ask you to think, well, why would 8033 apply and 8034 not apply? That would make no sense because this is for treatment. I'm not saying what the law should be, and it's straightforward and not very complicated. Should you want to ask the question on redirect, because the line of inquiry on cross-examination, as I you on that, and I'll then be happy to hear the Commonwealth on it and their objection, and if they don't. All right. Is there anything else you wanted to add, Ms. Reed?
It's just that I feel that this court ruling now has hamstrung me to the point where the defense has been eviscerated. I will continue with my direct of Dr. Dudley, but this ruling has eviscerated and so hampered its defense that it's taken on a constitutional dimension.
Okay. And there's the issue that you are talking the lack of clarity in the cases. Other arguments are based, that's not what the cases say. I disagree. I want to protect the record. That's the rest of your argument. The argument that you're making now, where you think the court is in error, the defendant told me he was hearing voices that very moment. That the case law, the defense, okay, just to keep the, that's the one thing that's not covered, that's not already covered by case law that you disagree with. As to that statement, that the defense is based on his opinion, relates to a physical condition or state of mind being admissible within 8033 at a 14B2 examination, then and Commonwealth versus Chapel would have never come out, or any of these other cases in the 14B2 examination for the Commonwealth and for the defense has a much, doesn't apply, which it has a huge probativeness problem. So that's the one sliver that the case law, from your perspective, isn't clear on. You're just saying that the existence eviscerates your defense. I get that. I get that statement.
I suspect that she would be an hour. The Commonwealth will be ready to present its rebuttal case on Tuesday morning. So I just wanted to inform the court that we don't have a full day of witnesses on Monday.
Okay. And as long as we're talking about it before the recess, your estimate is that you would rest on Wednesday, Ms. McDougall?
It depends, Your Honor. If all I have is my case on Tuesday, I anticipate I may be able to rest on Tuesday. If we're throwing Dr. DeVere in on Tuesday, that may push me into Wednesday.
Okay.
That makes sense. I know there are some motions the defense has filed regarding my case that will need to be heard at some point.
Sure. So maybe, it sounds like we have plenty of time on Tuesday to do that.
I mean Monday.
I mean Monday to do that after Dr. DeVere testifies. And I'll just tell the jury that they're not going to be here for a long time on Monday, and we'll have plenty of time to talk about it.
There is a motion in limine concerning some of the psychological tests that were done, saying that it doesn't meet the Daubert standard, and also relevance, because basically because they weren't normed for 16-year-olds.
So we've got, sounds like we'll have most of Monday to do this, right?
Right, but the Commonwealth's experts aren't available on Monday.
No, I mean,
Yeah.
they don't require voir dires, though.
I think for the psychological test, yes, it does. I don't believe they'll be lengthy voir dires, but they would require voir dires.
Well, we can do all the argument on all the motions other than what requires a voir dire, and then if after the voir dire the arguments have to be augmented, we'll do that. But I imagine we'll be able to get a lot of work done on Monday, and then that'll cut down the time for the amount of time for the voir dire on Tuesday. And maybe what I do is have the jury come in later on Tuesday.
I do want to be clear, Your Honor, I intend to ask Dr. Dudley about his failure to consider some of the testing that was done.
I don't want to say anything other than I understand what the defendant thinks the cross is going to be, and then I understand what the defendant's position is going to be at that point, and then we'll see what happens from there, is all I'll say.
The next thing is, Your Honor, I wanted to make sure that I objected to the court's failure to permit in the testimony of Dr. Gurr, Dr. Satterwhite, on the issue of the volumetric analysis of the defendant's brain being consistent with schizophrenia. I object to the court's failure to allow Dr. Dudley to rely on that, and also I object to the court's failure to permit Satterwhite or Gurr to testify concerning those issues.
Yeah, and there's one thing, I listed many of the reasons why I didn't allow it. I'm not going to repeat any of those, but in a short period of time I didn't add that what's done in the University of Pennsylvania and these studies and the views, that is just not applied in the litigation process, as the article indicated, without concerns about undue prejudice. But what I and I won't go over all that again, but it seems that the thrust of it is this is a way to address a building block of schizophrenia, and that's what would be a building block of the testimony here. That's not how it works in the outside world. One of the not frequently mentioned Dalbert Lanigan factors is if what's going to take place in the courtroom is different from the way things are evaluated or done by experts outside the courtroom. That's another Dalbert Lanigan factor. All right, so something else?
Just one more thing. Your Honor, the rule concerning expert testimony, I would like to be, I'm asking that Dr. Dudley be allowed to testify without hypothetical about facts that are already in evidence.
Well, there's, other than in Commonwealth versus Haing, which is the ballistics case, the SJC has never said that you have to form the question in a certain way. They did in that case about ballistics, reasonable degree of ballistic certainty. Other than that, assumed fact or hypotheticals is certainly a permissible way to have the expert give an opinion, but it is absolutely not a necessary way. So you don't have to pose the questions in hypothetical form. In other words, you don't have to go back to what a witness said and say, I want you to assume X, Y, and Z. Do you have an opinion? You can do that, but you don't have to do that, if that's your point. It is,
all right,
right?
well, we'll see how it goes.
No, but that's your point, right? That's what you're asking, that you don't want to have to use assumed facts and hypothetical questions for opinions based upon what's already in the evidentiary record. That's your request, correct?
Yes.
Okay, allowed. The case law does not require that. You can do it that way, but it doesn't require that. All right, let's see if we can.
I just have to speak frankly at this point. I read the transcript in the Peter Raunchy trial, and in that trial, the court, I believe, if they were going to say, if there had been, say if there was evidence that the defendant, a witness said the defendant went to the store, and if on the direct, if the defense wanted to ask the defense expert about that, the court required them to say, assume the defendant went to the store. How would that inform your opinion? Or if the defendant went to the store, how would that inform your opinion? But is the court's ruling that I can just say, did you consider the fact that the defendant went to the store?
Well, I don't remember the precise issue in the Ronke trial that you're referencing, but there was an issue in that case about whether bases were reasonable inferences or not from the evidentiary landscape. But the SJC has never said, as far as I'm aware, that in order to get to the opinion, you have to ask a question in a hypothetical or assumed facts. I don't know how many years ago that case was, but there was an issue going on about whether something was reasonable inferences. And what happens is, like, for instance, sometimes the hypotheticals, this particularly happens of concern with the Commonwealth, where the hypotheticals end up being things that there's not really a basis for, and they just become arguments to the jury. And there was, as I remember, a lot going on in that case like that. And so I can't tell you the precise reason for that. I can just tell you it seems clear to me that the SJC said many times that you can use hypothetical questions or informed facts based on what's in evidence, but you don't have to.
Thank you.
All right. 1050.